All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger coming at you live, 540-0580. Oh, well, as you guys know, I've been very, very busy. I did manage to get a few days off here, and so don't really have them off. I've been working all day on you-know-what, and I'll be working all the rest of the day on you-know-what, and then we start on Monday. So we won't be talking about that on the air, however, so can't do that. Can't answer any questions at this point. So anyhow, 540-0580. If you have a legal question, something pertaining to yourself, a friend, family member, maybe it's a personal injury case, maybe it's a divorce, maybe it's that proverbial tree hanging over the fence. That seems to be a popular one around here. Or the neighbor's tree roots pushing up your sidewalk. That's another common one. Or what happens when your neighbor's tree falls in your yard and lands in your pool, who has to pay for the cleanup, et cetera, et cetera, et cetera. Hey, we'll answer them here on the air as best we can. 540-0580, maybe it's a custody case, child support. Maybe you think you're paying too much or you think you're paying too little. I haven't had too many people say they were paying too little, but it's going to happen eventually. Some guy's going to come in and be upset that he's paying too little, and then I'm going to have to straighten it out. 540-0580. And, of course, as you guys know, you can go to romingerlaw.com throughout the week to look us up on the website, romingerlaw.com, or call the office if you need us at 717-241-6070. Corey, you're on the air with Carl. What's going on?
Hey, Carl. Thanks for taking my call. I have a rental property, and I was using a property manager, and we had the tenant evicted back in September or August. I'm not sure which month, but anyhow, I'm not working with that property manager anymore. When they evicted the tenant, we just decided I was done with it and whatnot. Mm-hmm. I just got a letter in the mail from him this week saying that I owe him $190. Now, I'm just wondering what you think about this, if I should even bother giving him the time of day or what.
So this is the old property manager?
Yeah, I mean, it's been like 8, 9, 10 months since I've worked with him now.
And this bill is based on what?
I don't know. He sent a whole bunch of paperwork along. It's difficult for me to figure out his invoices and reports and things.
Well, my position would be, if you don't think he did anything, I mean, I would look it over, and if you don't feel you got what you deserve or he didn't do what he was supposed to do, I wouldn't pay it. And then I would ask him for an explanation of why you owe it. And have him map it out for you. And if it seems reasonable, pay it. If it seems like, I'm not sure, maybe offer to pay part of it. But if you're pretty sure you don't owe anything, then don't pay something you don't owe.
Yeah, I heard you say that before, but the thing that got me was how long the guy waited to send me the bill for it. I mean, 10 months down the road? Come on, you know what I'm saying?
Yeah, that smacks us a little suspicious.
Yeah, I'm wondering if I pay this bill, 10 months more down the road, is he going to send me another one,
Right.
But at what point does it become excessive?
Well, that's the question. And so the short answer is if you don't pay it, he's going to keep making collections efforts, I guess. If you do pay it, you shouldn't owe him anything else, right? Because you guys aren't doing anything together anymore.
Well, I would hope not.
But is that clear? I guess I would want to clarify that before I send him any money.
I got you.
All right.
All right. Thanks a lot.
Hey, and the other thing is, remember, at the end of the day, he's still got to sue you.
Yeah. So what are you saying there?
So I'm saying right there, at the end of the day, he's still got to sue you. So if nothing else, if you can't work it out with him, you can always wait and see if he's willing to make that step to come after you. If you're not willing to capitulate and pay him any money.
Yeah, I got you.
All right, my friend. Good luck.
All right, thanks.
540-0580. Carl Rominger here answering your legal questions. Connie, you're on the air.
Hi, Carl. Thank you so much for taking my call.
No, my pleasure.
I have a question about managing an estate. My brother-in-law passed away this winter.
Okay.
And really didn't have any assets. But the one thing he did have was he had a loan out for a vehicle.
Mm-hmm.
And he paid for life insurance coverage on that loan, but he did not designate a beneficiary. And the only way that the holder would release that title was to an estate.
Right.
And at that point, we weren't going to establish an estate because he has nothing. So I did establish an estate, and now I have this vehicle. He has some debts that just two particular creditors that we need to deal with, but I've got this vehicle, and I need an understanding of what that vehicle means as far as the part of the estate. Is it an asset that I should go to first to sell to pay off his bills?
Right.
Well, this is or can I sign that title over to next of kin?
Well, that's the interesting question. The short answer is once you open the estate, you have a duty to the heirs as well as the creditors. And so you have to gather up all the assets, and if the only asset's the car, then it needs to be used to satisfy the debts before you can transfer any value out of the estate.
Okay.
So, and I don't know what the car's worth, but I'm just going to make some numbers up here. And say you owe $5,000 to the various creditors, and the car's worth $7,000. Well, you got to sell the car for $7,000, and then you got $2,000 to split up amongst the heirs because $5,000 is going to pay the bills. Okay.
Mm-hmm.
On the other hand, let's say there's $2,000 in bills, and the car's worth $7,000, and one of the heirs says, "Hey, I'll pay off the bills, and I'd like the car." And you'd say, "Okay, well, you can pay off the bills, but you're still going to have, $5,000 extra. So maybe you also need to give a few thousand to the other heir to even out the distribution." But there's lots of different ways you can do it, but you have to account for those bills. So you can't, as my favorite question I had on this show one time was, is it possible to leave the mortgage in my estate and the house to my kids? And I said, no, everybody would do it if it was possible.
Absolutely.
And that's kind of where you're at.
I have, with regard to that, on that same note, the two debtors that he owes it's just a bit less than what, as far as the cash goes. And I want to know if I'm wrong to try and negotiate that debt down.
Nothing wrong with negotiating it.
So if I negotiate that down, there's nothing wrong with saying I've negotiated down. I used the last penny in the account, and now that vehicle title is free and clear. I don't have to sell it in order to pay the debt. That's okay?
That's absolutely okay. Now, don't forget you're going to have to pay estate tax as well.
Yes.
But yeah, absolutely.
So one last question, and I really appreciate this, because are we better off if that vehicle or the value of the vehicle, which is better to give to the next of kin, the vehicle in the terms of estate tax?
It doesn't matter, because if it's cash or it's the vehicle, whatever assets transfer out of the estate are going to be taxed at the same rate. So it doesn't matter. If you
the value of the vehicle or what it was sold for.
Well, okay. Well, what it's sold for is going to be the value as long as it's a bona fide arm length transaction. So if you sold it to me, the presumption is going to be we didn't have a sweetheart deal. Mm-hmm. If you sell it to your brother, there's an argument that you might have sold it to your brother for a lot less than it's worth to hide the true value of it from the tax authorities.
Okay.
So, and they audit those things periodically. I've done a few estates where I get a letter that just says, send us, you guys claim this lawn mowing went on for a year on the house before you sold it. And they spot check you and just say, send us that bill.
Okay.
So.
This is very helpful.
All right.
Thank you very much for your time. You just cleared out a huge amount of confusion.
No, I'm glad I was able to help.
Have a great day.
All right, Connie, you take care.
Thanks, you too.
Okay, let's see here. Carl Rominger answering your legal questions. What's on the reminder list? Remember that the United States Supreme Court has not yet ruled on health care. Remember that the Ninth Circuit has just ruled that they will not rehear their throwing out of the California Proposition 8 gay marriage restoration, basically, in California. So that's probably going to the U.S. Supreme Court, just as a Massachusetts appellate court just knocked down the First Circuit. Just knocked down the Defense of Marriage Act as it applies to federal benefits. Be careful there, though, because the Defense of Marriage Act contains components that affect state law and components which affect federal law, and what's going to be constitutional or not constitutional may not be the same across the entire law. But we'll keep our eyes on those things for you, and as soon as we have more information, particularly on the one on healthcare, I want to really talk about that. Remember, I'm still claiming John Roberts for the surprise vote. 540-0580, Carl Rominger answering questions. Skip, Jason, Mike, hold tight. Oh, I'm working here hard online, ordering up a pizza for me and Shane. It's going to work. I like this. How you can do this now. You just pick it online. They're going to bring it here. I don't know how we're going to let them know we're here, how they're actually going to get in the door. We'll figure those logistics out in a minute.
Just have them leave it out front.
Okay, we'll try that. 540-0580. Carl Rominger here answering your legal questions. Skip, you're next.
Hey, there might be a bear out there, and he might eat that pizza before you get it.
Well, if there's a bear out there that eats that pizza and I shoot it, the game commission's probably going to put me in jail, like those other guys that shoot the bears in self-defense.
In regard to garnishing of funds.
Yes.
An individual moved out, broke his lease, had 4 months. He had 4 months left to go on the lease. He gets SSI. Can the landlord go after his checking account to get money from Social Security and SSI out of that
that's the
account?
$1 million question. And the good news is you can garnish landlord-tenant actions in Pennsylvania. The bad news is that federal law preempts when it comes to Social Security benefits. And to the extent that they are in a bank account, they cannot be taken.
Okay.
So,
but how would they go about it? In other words, do they have to go to the district justice first and get some kind of an order, or can they just do that?
You have to go to the district justice and get a garnishment order, and then you have to have the sheriff garnish the wages.
Oh yeah, but these aren't wages.
Or, I'm sorry, the bank account. Oh, in this case, then you'd levy on the bank account.
Yeah,
you'd levy the bank account that the wages are in or that the SSI is in, but to the extent that any of it's SSI or other Social Security benefits, the person's going to be able to exempt it.
Okay. And just one other question. If they would have to go to a district justice first, is that correct?
To sue somebody to get a judgment, yes.
Okay, so the person would be notified, and he could give his explanation as to why he left the premises.
Oh, yeah, absolutely. He could, what we say, defend and say, I really shouldn't have to pay because I was what we call constructively evicted, meaning that there was some terrible condition or repair not made. Therefore, they violated what we call the warranty of habitability.
Okay, but if you don't hear anything, then evidently, even though they threatened to do that,
they haven't done it.
They haven't done it.
At least, now, it's sometimes people do get sued and a lawsuit proceeds without them, but then later the other side is going to have to show that they did notify you, and if they can't show that they notified you, then it's going to be a nullity.
Okay.
All right?
Thanks a lot, Ben.
All right, good luck.
Bye.
540-0580. Jason, you're on the air. Hey, Jason.
Oh, sorry, I couldn't hear you. Hey, I have a question for you, more in regards to paying like a child support kind of thing.
Mm-hmm.
If there's never been any kind of custody agreement, my question is essentially, no child support's ever been paid in regards to like back support. If the child turns 18 and nothing has been happened before he turns 18, is there any recourse for someone to try to get child support after that child turns 18?
So nobody went after a support order.
Correct. There's no custody agreement. There's no support order of any kind for 18 years.
Right, and now the child's 18 and emancipated. I think under Pennsylvania law, no, you can't go retroactively.
Okay, I didn't know. But before that, that can happen. There can be back support before they're 18.
Well, theoretically, it goes back to the date of filing unless there's some kind of fraud. And then that is usually a modification. So I think that you have to, somebody has to affirmatively seek child support before the duty to pay for it accrues. In other words, if nobody's looking for it, if a husband and wife leave each other and the wife takes the kid and never goes for support, she has a right to seek it on behalf of the child. But until it's sought, I don't think any enforceable right accrues.
Okay, and you think certainly then once someone turns 18, there's no going back at that point?
That would be my belief, that no enforceable right accrues. Now, I'll give you an example. Let's say you tried to get child support and the kid was concealed from you, or the person was concealed from you, so you could never quite, make it happen. Then I think you could go back to when you started the effort. Pretty sure that's the law, but that's one of those ones where you might want to consult with somebody and sit down, because I haven't actually researched that scenario. I'm just going on what my general precepts are.
Right. Well, and that makes sense to me, and that's why I was just wondering. I know you probably don't specialize in that, but I thought just to kind of get your take on it.
Yeah. Now, and we do a lot of child support work in the office, but the reality is that's an unusual question.
Right. Okay.
All right, my friend.
I appreciate it. Thanks.
540-0580. Mike, you're next. Mike.
Hi, Carl. I had two quick questions on homeowner liability, please.
Absolutely.
The first was,
the neighborhood kids, in the course of when they're playing, they'll meander over into my yard. And I had a neighbor who advised me that when they're in my backyard, I ought to shoot them out. He said, because if somebody falls or otherwise hurts themselves, that I'm liable and could be sued. Is that true?
Well, you have a duty to invitees, okay?
Correct.
And social guests and people like that. And when it comes to children or even trespassers who come onto your land without your express permission, you still have duties to them. And those duties are to protect from known hazards, okay?
Okay.
So theoretically, if the kid just falls down in your yard, there's no liability. On the other hand, if he trips on an old rusty stake and falls and hits his head on another, old tent stake that you left in the ground, then the fight's going to be whether you knew the defect was there or not, that you knew the old tent stake was there. And, of course, somebody's going to say, well, you pitched the tent years ago. You never picked up the stake, so it's your fault. So you risk getting sucked into a lawsuit. But I always like to point out to people there's two things. If you have homeowners insurance, number one, they're going to cover you.
I have homeowners insurance. Yeah.
Right, so they're going to protect you, and they're going to defend you against any frivolous claims. So I think your friend's advice is very practical at one level because it's a strictly legal advice that basically says there's zero chance of having any liability whatsoever if you shoo these kids away. I'm a little bit more practical, and I figure if somebody's cutting through my yard, I don't care. And when I grew up, the kids used to come over, and this is a liability nightmare. Think about this. My older brother had left behind when he left the house all his hockey equipment, all the outfield street hockey equipment.
Yeah.
And we kept it in a garage, and you could, if you were a kid from anywhere in town, you came over and you opened the garage and you took out all the equipment you needed to play street hockey, because the Rominger boys had all the street hockey equipment in town. And they set it up on the fire hall parking lot and played next door. And then when they were done, they'd put it away. And the only complaint my mom ever had was they would leave the hose on once in a while. So, nobody ever got hurt.
Yeah.
And I guess that alone could have been a real liability issue. Think back on it as a lawyer now. But on the other hand, and from a practical standpoint, the odds of the kid wandering through your yard, having an injury, and the injury being your fault because of some negligence of you as maintaining the land. Now, if you had a goldfish pond, like these very beautiful ornamental ponds people like to put in now, which are quite capable of drowning toddlers, then I would have a much different take on it.
Okay. One other real quick question generally on this type of thing is like trespassing. What I don't understand is if a door-to-door salesman comes to your house,
right,
and he will say either in the winter slips on your sidewalk or in the summer will say your sidewalk's uneven and he trips and falls and hurts himself. Since he's trespassing, what I don't understand is why is the homeowner liable? I never understood that concept because you haven't explicitly invited that person to come onto your property.
Right, and you're only liable for known hazards that you didn't remove to trespassers. And here's the theory. The theory is that harm to anybody costs society at some level. And the person who's in the best position to fix a defect in real estate is the person who owns it and knows about it. So if you own the land and you know about the defect, we put a duty on you to fix it, even such that if a trespasser got hurt, you would be responsible. And so really what it is it's a way of allocating costs in society and saying you in the first instance should fill in the old well or remove the rusty nail from the boards laying on the ground, if that makes sense.
Well, my logic, where I get lost is my mind says, since you're on my property without my permission, why don't you assume the risk?
Yeah, and you do assume the risk of any unknown things, okay? Right. So as a business, if I invite you onto my property, I have a duty to be more vigilant in maintaining the property and knowing what's going on out there. Okay. So I have a higher duty. So there is different duties, but you're right, and it's a policy call at the end of the day because we could say, you enter other people's land at your own risk, because in that scenario, we would be saying it's more important you don't trespass. We don't care if you get hurt. So be warned that if you get hurt, you're not going to have any recourse, so just don't trespass.
I follow you.
But we go the other direction, because here's the reality. As much as we'd all like to see the trespasser fall into a giant hole and die,
right.
We'd also like to see him stamping license plates, or we'd like to see him on the side of the road sweeping, or we'd like to see him doing some other productive job or paying his child support. So that's kind of how that all comes to be.
Okay, well, I love the show, and I learn so much every week. I thank you so much.
No,
for your
thank
time.
you. Thank you.
Bye-bye.
Take care. 540-0580. Carl Rominger here answering your legal questions. Still trying to figure out how to order this pizza. Keith, what do you need to know? Keith.
Hey, thanks for taking my call.
No problem.
I have some student loans that, due to unemployment, underemployment, have fallen in default.
Okay.
And my question is that if I get an inheritance, are the feds, can they get their hooks into that money?
Well, I would think so. I would think that once any money's into you, once the inheritance vests in you, it's yours.
Okay.
That makes sense?
Right. Well, I've been working with the collection agency to rehab these loans, but they want $1,000 a month for 9 consecutive months to rehab the loan, and of course the outside collection agency has attached their fees to it and brought my student loans from say $35,000 up to $55,000. But they won't let me do what I can do based on my income to rehab these loans. Where do I go?
I think you want to go directly to, was it Sallie Mae?
Actually, this is through Fed Direct.
Yeah, you might go directly to Sallie Mae. I think you can deal directly with them.
Yeah, I tried to call them, but they say that they no longer have my loan.
Huh.
So I don't know what to do. And I don't trust the collection agency. I've been trying to work this out with them for almost 2 years.
Right.
They garnished my wages when I had a job, but now that I'm unemployed, there's nothing for them to take. And there might be a case where I might be coming into an inheritance. I don't mind paying my student loans, and I don't mind rehabbing them, but I don't want them to take, $55,000 because they're in default with those penalties and fees when,
right.
I could just rehab the loan for the 9 consecutive months and keep most of my inheritance.
Yeah, so that's a balancing call, right?
Yeah.
All right, my friend, I got to go to break.
Okay.
Trying to have a better answer.
Okay.
540-0580. See you guys after the break. Welcome back. Carl Rominger here, answering your legal questions, as I do every Saturday from 1 to 3. And, of course, you can join me on Facebook. It's Carl with a K. Last name's Rominger, Rominger. Feel free to friend request me. I still got a room for, a few more thousand of you, I'm sure. And besides, I want to make sure I have more friends than R.J. Harris. Although I like to watch his page, see what kind of pills he's taking most lately. He's always taking something. If you pay attention to the radio, just trust me. Do this. Play this little game with me. Pay attention to what R.J.'s taking on any day of the week. Sometimes it's fish oil. Sometimes it's a prostate pill. It's all over the map. Anyhow, 540-0580. Kevin, you're on the air. Hey, Kevin.
Yeah, Carl. My dad passed away a month or two ago, and I got a copy of the will.
Uh-huh.
And right in the first paragraph, it says that his funeral and the rest of the expenses should be paid. Funeral first, expenses after that.
Right.
Right. So I paid for the funeral. Now there's not a lot of money in the estate. If I mail my stuff to the lawyer or handling the estate stuff,
mm-hmm.
would I get it all back, or would I just be looking for a piece of it? Because I know I'm told that there's a substantial credit card bill. I don't know. I haven't seen it.
Here's the good news: the law of priority on estates is pretty straightforward, and so administrative costs and burial are first.
Right.
Then come creditors, and then come the heirs. So you're in priority. If you paid for the funeral up front, the estate still owes for the funeral, and you have priority above the other creditors.
Okay.
How's that for good news?
I thought if I'm only going to get a little piece of it, I wasn't going to bother with it. But if I'm going to get it all, then I'm going to go. Yeah,
your priority. So, any administrative fees of the estate, the lawyers for some reason are right up top as well. I don't know how that happened. The undertaker and the burial costs are up front for an obvious reason. If we design a system which put them at a low priority, it wouldn't be nearly as attractive and lucrative in a capitalist system for people to want to be undertakers and maintain cemeteries and do all the things we need to do to handle the burial end. So it's a practical. Again, I said something was a policy earlier. And that's a policy here. And a lot of what we do in the law, so people go, why is the law the way it is? It's designed to push things in certain directions. And so here, it's designed to encourage proper and adequate burial.
Right.
All right?
Yep.
And sorry about your loss.
That's good. That's all right. Thanks a lot.
All right, man. Take care.
Yep.
Bye. 540-0580. Andy, you're on the air.
Oh, hey, Carl. Love your show.
Thank you.
Just had a question, a First Amendment type question. I have a family member who belongs to a church, and as part of their church, they go around and pass out literature to strangers' houses. I think you know which church I'm talking about.
There's a couple of them, but I can narrow it down to one or two.
Yeah. But anyway, basically they were in an apartment complex, and I guess the manager came out and threatened to have them arrested and everything because they were trespassing, blah, 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 blah. I guess my question is, do you have a constitutional right to they weren't selling anything. They were just passing out literature. I mean, do you have a right to go door to door to pass out literature like that?
Well, the answer is we've seen that before where there'll be a no solicitation law or something, and when it runs into time, place, and manner restrictions, you can say, you can regulate the time, place, and manner of how people do this. But I'm not certain there could be a direct prohibition on knocking on people's door to see if they're interested in something, particularly if it's a religious or political type speech. Although you could certainly have an ordinance that says there'll be no door-to-door knocking without registering and without within certain hours. And if you think about it, there's a practical reason for that. That way we know who you are, although that might interfere with your ability to be anonymous like a good patriot, right? And on the other hand, we also regulate, time, place, and manner so that you're not being too intrusive. So
municipalities can't flat out ban. They can't say, okay, no passing out religious literature.
No, that would never pass muster. I had a lawsuit against Carlisle a number of years back that the Liberty tax waivers, the Carlisle Borough tried to cite the Liberty tax branch there was saying that their tax waivers were, soliciting and weren't properly permitted and weren't allowed to be out there. So the Statue of Liberties they have on the corner waving? Have you seen that?
Yeah.
So that's what they were saying. And, of course, my lawsuit was promptly dismissed by agreement when they consented to let them waive, because once they did the analysis on it, they came to the inescapable conclusion that if somebody wants to dress up like the Statue of Liberty and wave their hand on the corner of the street, that's their right. So let me take it one other step. Did you ever see when they're having a sale somewhere and they have a guy standing on the corner holding a sign that says, furniture sale, 1,000% off, blah, 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 blah. Well, that's how they get around, that's a guy with a sign and he's just walking around the street. So that way they don't have to have a permit, or that way they don't have to, it's not a permanent thing. It's just the guy's walking stick basically with a sign on it, sort of like wearing the old sandwich board.
Would the same thing apply for getting your name on a signature, for the ballot?
Right. I agree with that 100%. Now, here's your friend's problem. When you go into an apartment complex, then you're getting into a slightly different beast. Because if you're internal to an apartment complex, that's not public property. That's community property of the people who live there, and it's owned, and it may be strictly owned by the landlord. But on the other hand, it's hard to say strictly how that might work out. But once the manager says you can't be there, I think it's clear you can't be there.
Okay. Now, just if it's like a public street and you can't, if you're just going legitimately in the middle of the day saying, hey, do you want this religious literature, you can't be cited for trespassing if you're just on the guy's front porch or sidewalk or whatever.
Let me answer it this way. I've always wondered about that, right? Is it trespassing to walk up and ring somebody's doorbell? Because you've gone on their land without permission, right?
Yeah.
But it seems that we have an exception, which is going onto somebody's property in an unintrusive way to knock on the door or to approach them. I don't think has ever been found to be trespassing per se. And so if it's not formally written somewhere, it's at least a given that you can at least approach. Otherwise, nobody would ever be able to stop at some farmhouse and ask for permission to fish in the pond out back.
Okay.
Right? Just think of all the practical things you couldn't do. Or, hey, I found this trash can blowing down the road, and I looked, and you're the only house up the way from me, and I thought maybe it was yours, so I came and rang your doorbell and knocked on your door, and now you're having me arrested for trespassing because I was trying to see if it was your garbage can blowing down the street? I mean, think of all the things that so, no, there's an exception for that. On the other hand, I would imagine that if you kept ringing their doorbell once a day, every day, saying, you know, God sent me to ring your doorbell once a day and tell you about Jesus, that you're going to run afoul of something there, and that's going to become some kind of pattern of behavior.
Okay, got it.
All right?
All right, thanks, Carl.
Interesting question. 540-0580. Somebody called in, by the way, before I take the next caller. Somebody called in and said 1-800-4-FED-AID is a Student Loans Federal Aid Center. So it's 1-800-4-FED-AID.
And they basically said you can call in and they'll give you all the information you need about your student loans, when you took them out, when you started, basically all the general information you would need.
So that's, again, 1-800-4-FED-AID on your phone, and have fun and learn about your student loan. Hopefully that guy's still listening who's looking for help. Steve, you're on the air.
I'm still here. Hey, Carl, very nice to be speaking to you. I've been listening to you for a long time fan. You're a class act. I had a question as it relates to public transportation, specifically taxi cabs. Last night I was out with a couple friends. We were partying and having a good time. Did the responsible thing, took a cab. I usually have a responsible driver that gets me there, a regular driver rather, and she only charged me usually about $10 to get to where I'm going from downtown city out to the suburbs. And I wasn't able to reach her last night, so I had to take an alternate cab. I wasn't able to phone anybody or anything, but she got out here and realized I didn't have any cash in my wallet, so I had to backtrack down to, I guess, the Turkey Hill or whatever was close. And at any rate, to cut a long story short, by the time I got back, she told me that the meter was $52. I said, "You're out of your mind. Are you high? There's no way. I'm the one that's been drinking here. There's no way that makes any sense to me." And she insisted upon me paying that. I said, "There's no way I'm paying that." She said, "Well, I'm going to phone the police." I'm like, "Go right ahead." And in my patience, I said, "Well, you know, these police are going to come here. I haven't done anything wrong to anyone. And they're going to sort this out and say, you know, hey, you're ridiculous." And they say, "This is a pro bono ride. Enjoy." Of course, I didn't expect that. But, I mean, $15, $20 even would be a reasonable fare. But this was exceptionally high. And it was exuberant. I couldn't believe it.
So what happened?
Upon showing up, two different officers informed me that I would have to pay the meter. What are your thoughts on that?
Well, how did the meter get so high?
I have no idea. Now, I'm not going to sit here and pretend like I was sober, but by
yeah. So
but
maybe
all over town.
Maybe right. She may have taken you on an extra for a ride, so to speak.
Yeah, I mean, I don't think that she was waiting. She wasn't waiting for me anywhere. I didn't call. I got in the cab from a club downtown on 2nd, you know, like a lot of people do, right there. There was no waiting.
Yeah.
And, you know, in an alley cab. I can't imagine the fare being any more than 20. It's not my first ride in a cab. I'm a 40-year-old man.
Right. Now, I understand that, and you've had experience taking roughly that same ride. You know, there's two things that come into mind. First of all, because you're inebriated, we can't give up the idea that there's somehow you missed some salient fact along the way. But let's assume that's not the case for the moment.
Sure.
That's okay. Then if she did rip you off, that's the other problem. You're the drunk guy. Now, this is the practical problem, right? You're the drunk guy in the cab telling the cop that she's got the wrong meter, and she's insisting it's the right meter. And to dispense frontier justice, the officer's going to say, pay her.
Again, longtime fan, student of the law, a lot of lawyer friends, a lot of network big friends. I know this is not right. But I also know my hands are tied, my feet are to the fire. I'm the inebriated person.
So,
there's no way I'm going to make this make sense, especially to two uniformed officers. They, you know, I understand they were doing their job. I wasn't hostile or disorderly or anything like that. I just objected.
So I think it's in D.C. I think it's in D.C. when you take a cab, they can't charge you more than certain amounts if you move from one zone to another zone.
Okay.
And that's been designed to prevent the cab drivers from taking you for a ride, so to speak.
Sure.
And the idea is if you go from A to B, your fee's going to be the same. Now, sometimes it stinks because, you know, you move from one zone to the other or whatever it is, and they can get you, still tag you for a good fee, but other times it'll cap out on them. So I know that this is a known problem in the industry.
It is. And you're a traveled man. You know that specifically in Harrisburg, and I hate to bash people. One of my good friends is an owner of one of the local companies. But enough's enough. But I mean, I've been in businesses where we've used cabs for many years, and I've seen people get in the stick, get in the shaft. These people are unprofessional, and I'm tired of it. And this just seems like an impetus to me to maybe take some action. And I
don't know what action to take, though, Steve. That's the $1,000,000 question. Shane, do I have to go to break? Oh, I have to go to break, Steve. All right. Good luck.
That's okay, Carl. But hey, thanks for your time.
I like the story, too. Keep drinking. Talk to you later.
Liven up your afternoon anyway.
All right. So, we had that whole conversation about walking around, handing out tracts, and knocking on people's door. And, of course, what do I see in today's newspaper? Putin signs law imposing fines for unsanctioned protests. Basically, you can get these big fines if you take part in an unsanctioned protest. Now, think about that. That's right, an unsanctioned protest, because you need your protest sanctioned by the very authority you are protesting. And that's one of the reasons why we have to so vigilantly protect the First Amendment, because that would not stand here in the United States. And we are neither Iran nor Russia yet. Who's been holding the longest? Tom has. How are you?
Good, Carl. Thanks for taking my call.
My pleasure.
And know that lots of people will be watching next week with great interest. But anyway, let me tell you my story. I was driving my father's vehicle in the state of New Jersey when a trooper pulled me over, and I was going over the speed limit, no doubt about it. He gave me a warning for speeding, but he did give me a ticket because the license plate was improperly displayed or unclear. There was a reflector around the outside of it, and you could not read that it said Pennsylvania. It's, as I said, it's my father's vehicle. $54. I thought, oh, that's not bad. I sent in the money to them. I did write a note and asked them to dismiss the charge because my father felt very badly about this, and it has been removed, and I asked him to dismiss it.
Right.
I got a form back in the mail with a sticky note attached saying, if you would like to enter a not guilty plea, please fill out this affidavit and return it to the court. Are they inviting me to plead not guilty?
I think they're just telling you that in order to set up a hearing on it, you need to plead not guilty, that otherwise it can't be dismissed, because your option at this point is only, with the court, is only to either plead guilty or plead not guilty and set up a hearing. The officer could withdraw it, but your correspondence to the court probably wouldn't make it to him.
All right.
And by the way, that's a winner of a case.
In what way?
Well, a long time ago, I had a very similar charge, and as I said under cross-exam, this was my own license plate with the license plate holder around it.
Right.
I had some very upset officer couldn't find any other. This was one of these like witch hunts where he couldn't find anything else I had done. So he charged me with my push bar grill was obscuring my headlights. And my license plate holder was obscuring my license plate, and my tint was illegal. Well, anyhow, eventually won them all. But on the license plate issue, the issue was this. As I said to officer in cross-examination, now, when you called the plate in, what did you call it in as? I called it in as PA, blah, 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 blah. Like, well, how'd you know it's Pennsylvania if the holder obscured Pennsylvania? And the judge was like, yeah, come on now. We all know it was not a material. And then the other thing the judge said, this is like the holder that all the car dealers put around the license plates. Is that what we're talking about here? You know what I mean?
Yeah.
And so you'll find that you'll probably have a warm reception in court if you want to defend that. Not in every district judge office in the land, but in most.
I see. Okay. All right, that's interesting. And part of me is saying, okay, he was kind to me. I was 15 miles per hour over the speed limit.
And that's the next question. So maybe he wrote you up just so he could do a ticket because his supervisor, doesn't want him coming home empty-handed, because then the wheels of justice don't provide funding for the government.
Mm-hmm. Yes. All right. Okay.
All right, my friend.
This is not the case where only the owner of the vehicle is responsible.
I think as operating it, you're duty bound to operate it in a condition. Now, you're not a commercial driver, and you don't have to pre and post, but still,
I'm not a commercial driver.
Yeah, but and it wouldn't even be a vehicle that would require it per se. But my point being is, you're still deemed to know it, and actually, that's why there is a case out there where some poor truck driver didn't know that some VIN number had been filed off some trailer he picked up, and the courts finally said, well, yes, it's strict liability, but he didn't know, and there's no way he could have seen it, and it's just hitched up, and he hauls it away. So it's just fundamentally unfair to convict him. So I guess you could run with that argument.
Well, to pursue the argument, I really need to be there.
Yes, and here's the other.
I don't know if I want to go to New Jersey.
Yeah, it's not worth it. And here's the other thing. The other thing you're going to find is that he probably could still bring back the traffic violation if you challenged it. And that might be the real problem.
That would be. Okay.
All right, my
friend. Thanks very much, Carl.
Take care. Didn't mean to cut you off. Sometimes I hit that button too fast. 540-0580, Carl Rominger here answering your legal questions. Trying to figure out when my pizza's going to get here. Bobby, you're on the air.
Oh, hi, Carl.
How are you?
I'm good. I hope you can answer my question for me.
Sure.
On,
I can try. That's all I can promise.
Paying condominium fees.
Okay.
We have 105 houses in our condominium, and one of them is in bankruptcy for about 4 or 5 years now. They keep supposedly paying something towards it, but they're not out of it, is what they're telling us at our condo meetings. So the problem is they haven't paid any condo fees at all in the past 4 or 5 years, which is significant. It's now like $10,000 or so. Of course, they still continue to, use the amenities, park the car, have the trash, the pickup, everything that we're paying for.
Right.
They're getting. And it just doesn't seem, every time I go to a meeting and I listen to counsel or listen to what they say about what the attorney they have says, it just gets me nuts. Is there anything we can do, and is there anything in the future we can put in our bylaws for something like that?
Yeah, once people go bankrupt, the problem is that stops any collection activity. And that's a typical problem. Now, I do think that your counsel could go for some kind of special relief in the bankruptcy court and say, we're getting to the point where this is ridiculous. We need some flow because this isn't just damage. This isn't just one debt that needs to be paid. This affects the ability of the condominium association to manage its property.
Right.
And that's what's unique about condominiums, is you guys own the outside. The association owns the outside of everything, right? So the fees kind of are a necessary part, even more so than some homeowners associations, arguably. So I don't know. I think that they could go to the bankruptcy court and ask for special relief. But the question is, if there's no money there, maybe not. But apparently there must be some money there if they're parking a car, because that takes gasoline.
Well, that's a point.
So I would tell you, your counsel probably needs to talk with bankruptcy counsel. I got to go to the next hour here, so I'll talk to you later.
Thank you.
All right, guys. See you next hour. In the meantime, Rominger Law. If you need a lawyer, see you in a few minutes.